All right, you guys ready? All right, sounds good. And sorry if you guys hear some noise. There's a Super Bowl party happening at my house right now. All right, so let's start with question one. Like you guys have heard me say a million times, there you always want to start by reading the call to question, and particularly because it might just help you figure out what subject you're in. So like here, question one, is this requirement constitutional? That just makes it easier. You can evaluate something you're determining if it's constitutional. It's an open and broad question, so it kind of leaves you open to like all of con law, um, but at least you know what subject you're in, which is a good thing. Um, Con law questions tend to be kind of nice because they tend to be shorter fact patterns. They tend to be shorter. They tend to be like somewhat straightforward. You don't get all the ambiguities like you do. You don't get all the ambiguities like you get with the con law essays, which is a good thing. Con law questions in particular, though, you will see a lot of, you really need to know all the different burdens and who has to prove it. So make sure you've got all of those straight in your mind, especially the differences between the burdens in First Amendment and in equal protection due process claims. Because there's some differences there, and they will test you on those differences. So I don't think we'll actually see that tonight, but I know that does come up. So just make sure you're looking out for that. All right, so let's look at question one. Due to a notable increase in, or so is this requirement constitutional? Due to a notable increase in prostitution arrests in the state legislature has enacted new regulations for massage parlors. So you'll often see when something's dealing with the police powers, you're often going to see like vice crimes. So increased drinking, increased drug use, prostitution, etc. So stuff like that. So like you want to, if you see that, then you're thinking police powers, and those are okay. The new law requires that all workers at any massage parlor or similar business be licensed by the state attorney general. That is completely constitutional under the police powers of the state. So that's what I was looking for, and that's answer choice A. So B, yes, because the attorney general is designated as the proper person to enforce the law. That's fine. It doesn't really matter, but it doesn't answer the question of whether or not it's constitutional. So just because you're looking for a constitutional basis for this being constitutional. So you're looking really for a particular provision, whereas B doesn't really give you that. So you can have someone designated, but they can be trying to enforce something that's improper, which is not okay. So then C, no is a burden on interstate commerce. So even so no is a burden on interstate commerce. So this doesn't burden interstate commerce. It's just requiring a licensing scheme, so anybody can still carry on. And then D, generally speaking, privileges and immunities is going to be an incorrect answer. So I know that as soon as I go into this, but also this doesn't violate the privileges and immunities clause of Article 4. And let me actually explain. So you guys have the answers as well, but I just want to go into it. So the point there, it says interstate privileges and immunities clause doesn't protect corporations, and there is not an indication that it's treating non-residents differently than it's treating residents. So that's why. And then with C, with respect to interstate commerce, even if it does burden, it's probably going to be permissible because you're dealing with the vice crimes there, and you want to avoid those. So that's question one. Question two. So this gets to the burden of persuasion issue. So which of the following statements concerning the burden of persuasion applicable to the suit is correct? So it's basically asking you to define the burden of persuasion. So you're looking for what type of violation is present or what type of a challenge is present. So you're looking for, what type of classification is this? And then rendering a decision on what the burden of persuasion would be. So here it says a state statute provides that only citizens. So as soon as I see citizens, I know it's alienage. So I think that it's strict scrutiny. I think, but I want to keep reading. Of the United States may be employed by that state. In an action brought in a federal court, a resident alien, so there's an alien, who is prevented from obtaining state employment as a garbage collector solely because of his alien status. So that's the only reason why. Challenge the state's constitutionality as applied to his circumstances. So he's saying that there's a discrimination based on citizenship or alienage. So that is subject to strict scrutiny. And the state must show that it has that the requirement is necessary to achieve a compelling government interest. So I'm looking for that standard. And so I'm looking for the state must demonstrate, which is C and D, and then necessary to advance a compelling state interest. So that's answer choice D. A, B, and C all just state incorrect standards. So A and B, and they'll do this where they'll switch the language around. It's saying, who has to prove it. So you're looking at, does the plaintiff or the defendant have to prove it? And then, so A and B are out because of that. And then, so it's C and D, and C just states the wrong standard. That is the requirement for rational basis. Any questions about the first two? Okay. All right. So question 3. So which of the following is the strongest argument that both parts of the ordinance are facially unconstitutional? So we're looking for something that's just facially unconstitutional. So here we have a city adopted an ordinance providing that street demonstrations involving more than 15 persons, so this looks like a time, place, manner restriction to me, may not be held in commercial areas during rush hours. So I'm like, all right, well, what are rush hours? So that looks like it might be a vagueness issue challenge. Exceptions may be made to the prohibition on 24-hour advance application to and approval by the police department. So that looks like it might be an unfettered discretion issue. So that looks like an unfettered discretion because it's putting it solely within the hands of the police department to determine whether or not to grant an application. The ordinance also imposes sanctions on any person who shall, without provocation, use to or about someone and in his presence opprobrious words or abusive language tending to cause a breach of the peace. So that looks like it can be incredibly vague. That just looks like it can be vague. So because who knows what, I mean, generally speaking, you can get from context that it's like offensive language. But opprobrious, people might not know how to interpret that, or abusive language. What is that going to mean? And that's going to mean different things to different people. And no court has, as of yet, interpreted the ordinance. So that also, again, looks like it's going to give unfettered discretion to police department in determining what to do. So which of the following is the strongest argument that both parts of the ordinance are facially unconstitutional? So we want to look at each of these. So A, it says no type of prior restraint. That's incorrect. That's an overstatement of the law. There are some types of prior restraints that can be imposed on speech in public places. So that is an absolute. So A is incorrect. Laws regulating by their terms expressive conduct or speech may not be overbroad or unduly vague. So that's getting at the unduly broad and over vague. Unduly vague and overbroad. But I don't think that so that one is kind of a maybe to me. That one is kind of a maybe to me, but I think that the stronger one actually deals with the police issue, because there's been no interpretation of the second one, and the exception puts all the power within the police on the first one. Let me just double check and make sure that I'm good on that. I think this is. Oh yeah, no, actually it's overbroad, right? Yeah, that's overbroad. Okay, sorry about that. So both of them have broad provisions. So they both have broad provisions. The first one regarding rush hours, and you note too that they put rush in quotes. And then in the second one, so I guess actually, the difference really between the two is that the first one has the rush in quotes and has the exceptions for the police powers, and the second one has really vague terms, and there's nothing that indicates the police powers, although I think you can make an argument there. An easier challenge to win is just going to be based on its face, and that's probably why it's the word facially unconstitutional. So just on its face. So that's why it's probably going to be the better argument is overbroad. So which is why B is correct. C, the determination as to whether public gatherings may be lawfully held cannot be vested in the police. So that also that's an implied absolute. So it's just saying like the police can never determine whether public gatherings may be lawfully held, and that's incorrect. That's an implied absolute. So you want to watch out for that. And then D, the right of association in public places without interference is ensured by the First and 14th Amendments, and that's also like again, the A, C, and D all have an implied absolute. A has an express absolute, and C and D has an implied absolute, where it's creating this absolute and saying that you can never have this. You like in C, that the police can never determine whether public gatherings may be lawfully held. And the right of association in public places without interference is ensured. That's saying that that's ensured at all times, and that which is incorrect. So A, C, and D all are a bit too extreme to be correct, and especially when you're dealing with a facially unconstitutional issue. With here, just looking at the terms of the statute, you can pick out words that would be overbroad or vague. Does that make sense to everybody? Okay. All right. So question 4, to satisfy constitutional requirements, how much money must the Secretary of Health and Human Services distribute for the dental education program this year? So it's asking what a specific person, I guess a cabinet member or a government employee, how much they have to distribute. So because it's asking that, that kind of hints at constitutionality because it's a government actor. So it's, what must they do? So here we have a federal statute set up a program of dental education. The statute provided that the Secretary of Health and Human Services shall, on a current basis, spend all of the money appropriated for this purpose. So once there's a designation by the government for that, then it has to be adhered to. And it says, and shall distribute the appropriated funds. So then that person, they have a duty to distribute the appropriated funds as directed by a specified formula to state health departments that agree to participate in the program. In the current year, Congress appropriated $100 million for expenditure on this program. To ensure a budget surplus in the current fiscal year, the President issued an executive order directing the various cabinet secretaries to cut expenditures in this year by 10% in all categories. He also ordered certain programs to be cut more drastically, and so the President here is going beyond his powers, executive powers here. So there is kind of an open question about the limits of the president's powers, but one thing the president can't do is unilaterally suspend the effect of a valid statute imposing a duty to spend. So that is something that has been determined, so you just kind of need to know that rule. So as soon as I see the president contradicting what has been ordered to be spent, then I know that he's violating the law. So he also ordered certain programs to be cut more drastically because he believed that they are not as important to the general welfare as other programs. The president identified a dental education program as such a program and ordered it to be cut by 50%. Assume that no other federal statutes are relevant. So how much money must they spend? And they have to spend all of it. You can't just spend part of it or 10% or cut it or whatever. They have to spend all of it. So I'm looking for $100 million, and the only one that has that is D. So D is the correct answer. And then so A, B, and C are all incorrect. A, B, and C are all then incorrect because they would allow for some of that elimination of the federal funding. So D is the correct answer. Any questions about that one? So you really need to know this rule stated in D. That's kind of the takeaway. All right, let's look. Common law questions go quickly because they tend to be a bit shorter. All right, so question 5. How should the court proceed? So we don't know what subject we're in. If you're on the bar, you wouldn't know right away. But there's some hints. So when we go to the question, we'll see that. So responding to an open bid solicitation from the procurement office of the Defense Department. So I start to see government agencies. When I start to see that, then I'm starting to think, okay, well, maybe we're in con law. So responding to an open bid solicitation from the procurement office of the Defense Department, a technologies company submitted a bid for the development of a new flame-resistant fabric. On the review of the bids, the company was notified that it was the low bidder. However, its bid for the contract was denied because of its failure to meet guidelines on minority representation that the procurement office imposed on firms contracting with the Defense Department. Those types of guidelines are totally constitutional. They're allowed. They exist in most governments throughout the U.S., so state and local alike. So several months later, the project was rebid. So this is a rebid of it. Although the company did not participate, company officials later learned that the contract had been awarded to another regional company after the procurement office waived its minority representation guidelines for that project. But the company here, if it didn't participate, then it doesn't have standing to bring a claim because it didn't participate in this one. So I don't think they have standing. The company whose bid had previously been rejected filed an action in federal district court seeking only to enjoin performance of the contract. So how should the court proceed? So if they're seeking to enjoin it, and they can't do that because they don't have standing. So how should the court proceed? So I'm looking for them to dismiss it on the basis of lack of standing. So dismiss the action because the company cannot show a relationship between the procurement office award of the contract and any injury that it may be claiming. So that, in so many words, is saying that they lack standing. And so this is something that you guys need to see. Is you need to see various ways that the bar examiners will state something. So they could say, dismiss the action because the company lacks standing, but instead they're kind of connecting two things. They're saying that they haven't suffered an injury based on the government's conduct, which is essentially saying standing, but they're putting it more complicated. So you need to see A as them saying lack of standing. B, dismiss the action because the federal government may enter into contracts under whatever conditions it chooses. That's just not true. That's not true, and that wouldn't be a basis for dismissing the action at all. So B is out. C, decide the case on the merits so it's the wrong result. Because the procurement office must show that its waiver of the minority representation guidelines was necessary to further compelling government interests. That's not true. It doesn't matter that it's dealing with race or anything else. So that doesn't matter. And then and so especially to put it to such a heavy burden here, so to make it show that it has a compelling interest. And then D, decide the case on the merits, because the company can claim that the unequal treatment of the two bidders violated its rights under the Due Process Clause of the Fifth Amendment. They didn't. So what this is essentially saying is that they had a property right in it, and they did not. They didn't have any sort of a vested property right because they didn't bid on the contract and lose it. You have to have some sort of an entitlement to trigger the Due Process Clause of the Fifth Amendment with respect to work. So D is incorrect. So A is correct. So yeah, so I think the big takeaway here is just making a note, and this goes for a lot of questions. You're going to see the right answer, and you're going to see them saying a rule, and it might just be like that they're saying it in a very weird way, but that's something that you really need to pay attention to. So all right, let's look at the next one, number 6. All right, so in light of the nature of the rights involved, which of the following is the most probable burden of persuasion on this constitutional issue? So this is telling you that this is a constitutional law question. All right, so a state statute requires the permanent removal from parental custody of any child who has suffered child abuse, which seems like it could be vague, but then it goes on to say that term is defined to include corporal punishment of any sort, which seems okay. I mean, you can say that that's vague too. A father gently spanks his 6-year-old son on the buttocks whenever he believes that spanking is necessary to discipline him. Right, so this seems like sort of a common thing. Such a spanking has never physically harmed the child. The state files suit under the statute to terminate the father's parental rights solely because of these spankings, which this seems a bit extreme. The father defends only on the ground that the statute in question is unconstitutional as applied to his admitted conduct. So the right to parent is a fundamental right. So as such, the burden is necessary to achieve a compelling state interest. So I know that that's what it is, and it's that the state has to prove. So it's strict scrutiny, and the state has to prove it. So so that's what I'm looking for, the burden of persuasion, and that's it. Like, you don't need to. As soon as you identify what type of right is involved, and remember that strict scrutiny applies to fundamental rights, and so you should know what all of those are, and they include parental rights, and it's also subject to classifications based on race, alienage, national origin. What's that fourth one? Race, alienage, national origin, and there's that. It's also kind of related to parenting. It'll come to me in a second. But you should make sure that you know, especially all of those fundamental rights. So I was just looking for strict scrutiny, and A states strict scrutiny. B, C, and D don't. B states, it has the wrong party. Well, it has the right party, but it has the wrong rule. C and D are also incorrect because it's saying that the father has the burden of persuasion, which he does not. All right, so any questions about 5 or 6? Okay, Good. We're kind of flying through these, which is good. All right. All right. So question 7. So if the court rules that the bank's rights under the Due Process Clause of the 14th Amendment were violated by the state's seizure of the property, what is the most likely reason? So with the phrasing of this question here, saying if the court rules that it is a violation, what is the most likely reason? So there can only be one. So you have to look for the one that is the only way that the court will rule that the bank's rights were violated. So that's what we're looking for. So a state statute permits the state to seize and dispose of real property that was used to commit or facilitate the commission of a felony drug offense. After a drug dealer's arrest for selling cocaine out of his home, a felony, so he's committed a felony, so that statute applies, the state instituted an action of forfeiture against the drug dealer's house and property. So that seems like that's kind of a big loss. After notice to the drug dealer and a hearing, a judge granted the order and the state seized the property. 6 months later, after the time for any appeals had expired, the property was sold at a public auction to a third party. It was only then, it was only when the third party brought an action to quiet title that a bank holding a properly recorded mortgage. So notice here that it's a properly recorded mortgage. So had they done a title search, has the state done a title search, they would have been able to notify the bank, and that's really important. So because the bank does have a major interest in the property here. So that actually I should highlight as well. Dealer properly recorded mortgage on the drug dealer's property, learned of the forfeiture. So when there's a properly recorded mortgage and property is being seized, you have to notify those with an interest in it that it's being seized, and you do have to give them pretty solid notice. So you can, you probably have to, reach out and contact those people particularly. So because the bank's mortgage payments were automatically deducted from an account the drug dealer had under a different name, no one at the bank was aware that the property had been seized. The only notice provided to parties other than the drug dealer was a public notice published for 3 weeks in a general circulation newspaper. Those public notices are really rarely seen. Like they're often published. Like there are just newspapers that really deal with these types of notices. In San Diego, there are some, and they're rare. Like they're not your big newspapers that everybody gets. So they're a bit more obscure. The bank defends a quiet title action on the ground that it did not receive the notice required. So they're getting to the notice that it did not receive the notice required under the U.S. Constitution, protect its interest in the property. So the bank is going to win. So what's the most likely reason? So, and they're challenging it based on lack of notice. So I think the answer should probably include notice. So here, let's go through the answer options. And I put the rule here. So if the government's taking a property interest, it must give notice to those persons whose property interests are at stake. And the bank does have a property interest at stake because it has a mortgage. The notice must be reasonably designed to ensure that those persons will in fact be notified of the proceedings. So that means giving more direct notice. So because it says reasonably designed to ensure, and the fact that it's a properly recorded notice means that the only thing the government has to do is probably mail something to them, mail something to the bank. And that's pretty easy because it's a recorded interest. So, all right, so let's look at these other options, or the options. In any judicial proceeding affecting rights to real property. So that's a little broad because it says in any judicial proceeding, which makes me question it a little bit. A claimant is required to provide notice and an evidentiary hearing to all parties with the legal interest in the property before taking actions affecting their right. That just seems to go a little bit beyond. We have to give notice. So A is out. The government itself was the party that seized the property rather than a private party using governmental processes. That doesn't mean that it doesn't apply. That's even more reason. So B is sort of a nonsensical answer to me. B is out. C, the notice was not adequate under the circumstances to apprise a party with a properly recorded legal interest in their property. And that gets exactly to the heart of the issue, that it was properly recorded. And as such, the government had to provide notice that's reasonably designed to ensure that they will in fact be notified. And that just means you just got to mail something to them, and it's easy. So C looks good. And then D, the jurisdiction treats the mortgagee as having title to the property rather than merely a lien. That doesn't matter. They still have an interest. So D is not a basis for it being, that wouldn't be a reason under the Constitution. So C is correct. Any questions about that? Okay. Alrighty. Yeah, we're flying through these ones. Okay. Um, all right, number 8. Pursuant to a state statute, a student applied for tuition assistance to attend a university. Oh, sorry, we should read the call first. So, is the state's restriction of such grants to United States citizens or resident aliens seeking such citizenship valid? So, like, I'm already questioning this because it's dealing with a restriction with respect to citizens and aliens. And so I'm thinking that, okay, well, this is subject to strict scrutiny, which almost always is fatal, or will almost always fail. So a statute's probably not going to be held to be constitutional. So, pursuant to a state statute, a student applied for tuition assistance to attend a state university. He was qualified for such assistance in every way. So the fact that it says qualified in every way, except that he was a resident alien who did not intend to become a U.S. citizen, like that makes me think that they are discriminating based on alienage or citizenship. So, which makes me think that it's going to be subject to strict scrutiny, and I know that's generally speaking going to be really difficult to show. So I don't think it's going to work. But let's just check the other answers. Um, so actually, let's look at no first. So C, no, because the justifications for this restriction are insufficient to overcome the burden imposed on a state when it uses such an alienage classification. I think that looks pretty good because that's essentially saying no because it won't meet strict scrutiny, which is what I think. D, no, because the Privileges and Immunities Clause does not permit such an arbitrary classification. It's not. It's not under the Privileges and Immunity Clause. That's citizens of one state over another, and it's not. So that doesn't work. So D is out. So I think C looks pretty good because I don't think it's going to pass. We got to check A and B. So A, yes, because aliens are not per se a discrete and insular minority, especially protected by the 14th Amendment. I don't. Gosh, let me just double check on that one. Um, oh yeah. So well, and I'll just with respect to D, it doesn't apply to aliens, so that's why. Um, so here, um, yeah. So I mean, they actually don't provide really an explanation of why A is incorrect, but I don't think that they are a per se discrete and insular minority. And I also don't think that that's a basis for finding that this is valid because it doesn't deal with the fact that you still have to pass strict scrutiny. So A is incorrect. So B gets to so there is an exception for alienage, and that's when you're in certain types of jobs. Then they can use that as a basis, but that's not applicable here because this is filing for tuition assistance. So B is incorrect. Any questions on that one? So that's question 8. All right, so let's look at number 9. So will the court find the statute constitutional? Again, this is why you want to look at that. Or you want to look at that call of the question first because it's going to give you some hints. All right, so number 9, with the stated aim of protecting minors. So as soon as I see that they're trying to protect minors, I'm thinking, okay, well, are they doing so at the expense of other groups that have protected rights? So if there is a way to have something that regulates, that protects children, but doesn't affect constitutional rights of adults, then we have to take that less restrictive means. So generally speaking, you're going to see this come up in the context of some obscene material, and you're going to see it come up in a commercial arena. So it's like if you go to 7-Eleven or a market like that, how they can sell stuff that's considered kind of pornographic, but they put a cover over it. So and it says must be over 18 to view. So kids aren't allowed to, and they usually place them up on higher shelves. Not that I go in like looking for these things. I just remember like noticing it. Um, so so there is a way to protect. So that's what you want to look for. So with the stated aim of protecting minors from the perceived evils of offensive but not necessarily obscene. So this is telling you that it's material that might be constitutionally protected because it's not obscene. So they're explicitly placing it outside the context of unprotected materials. A state legislature enacted a statute banning the commercial licensing of video arcade games with a specifically defined degree of sexual content. So this is getting at exactly that scenario that we were looking for. And so you'll see this here, you'll see it with, I've seen examples or questions like this that deal with magazines, and they're trying to sell it at a video store, something like that, or a video. You might I think of like Blockbuster Video, and you can have that section that's like an adult section. Like those types of things are okay, and they allow people that have a right to access it, and those that want to sell it. It allows them. It allows people to have their access while still protecting kids. So under the statute, the owner of a chain of shopping mall video arcades in the state was denied licenses for a number of video games that he wanted to install at his arcades. He challenges the statute in federal district court. Will the court find the statute constitutional? One thing to note too is just always be careful that you know whether it's the question says, will the court find the statute constitutional or unconstitutional? Because that can just kind of be tricky. And when you're reading these quickly, it can be easy to sort of go over that. So that's why it's also good to read the call of the question first, because you're like, all right, is it constitutional? And you come back to it and make sure that you've read it properly. So I'm looking for a no, and I'm looking for the reason that I thought, which is, okay, well, this is minors, but do you have to deprive everybody of it? Or is there a way to protect the minors while still allowing the adults? And there is. I can just come up with a plausible way to do that. So if there is a narrower avenue, then they have to take that. So I'm looking for that. So I'm looking at C and D. So no on C, because narrower means are available to deny minors access to the objectionable material without affecting the rights of adults. It gets to exactly the scenario that we were looking for. D, no, because some of the banned video games may have serious literary, artistic, political, or scientific value. So that's getting just more to the test of whether something is obscene, and these have already been determined to not be obscene. So D is out because it's just stating something that's irrelevant. So then A and B, which I don't think are correct, but we want to go through anyways. A, yes, because for materials accessible to minors, the state may adopt a different standard for determining whether the material is offensive or obscene than the standard applies for adults. That doesn't matter. So, I mean, that's not a reason for finding it to be constitutional, because the adults are having it withheld from them as well. So A is incorrect on that basis. And it's also just sort of irrelevant because it's irrelevant because it's affecting the rights of adults. So that's out. And then B, yes, because the statute precisely defines the type of content that is prohibited in the video games. So that's essentially saying that it's not vague, and just because something's not vague doesn't mean that it's going to be constitutional. It can be found to be unconstitutional on other grounds, and it is here, because it's withholding something without that people have a constitutional right to. All right, and then question 10. So should the court entertain the atheist suit? So as soon as I see atheist, I'm thinking, okay, this is, free exercise, freedom of religion. I'm thinking those types of issues, but just keep an open mind. A small village had a population of 400, and 90% of the inhabitants belonged to the same church. The village council consisted of 5 members, all of whom were members of that church. The council unanimously appropriated, so then when I see appropriated, that means taxes. They appropriated $350, or it's government act on money, $350 to pay a landscaper to mow their church's lawn for a year. An atheist in the village who lived in a tiny house and paid only $200 per year in village and country property taxes was incensed that any of it should go to support the church. So generally speaking, someone doesn't have standing based on taxpayer status, but there is an exception to that. And the exception to that is that it's a violation of the Establishment Clause if it's if the government is using money that someone has paid for religious purposes. And here, you can definitely argue that the money is being used for religious purposes because it's going to mow the church's lawn for a year. So he's basing his religious beliefs or non-religion beliefs. Well, I guess that is religious beliefs. It's just anyways. So he's taking that, and so he does have standing to bring this claim on that basis. So that's what we're going to look for, and which is in there in answer C. So the atheist filed suit in federal district court to strike down the council's appropriation to mow the church lawn. So it's saying, should the court even entertain the atheist suit? And yeah, so it's saying, does he have standing? That's what that question is. Should they entertain it? And yes, they should, because yes, he does have taxpayer standing in this instance. So C is correct. A, no, because the atheist paid so little in taxes that his interest in the matter, if any, is too minimal. That's just incorrect. That, as long as you do have an interest, then you have standing. So A is incorrect. B, no, because taxpayers lack standing to sue over appropriations by duly constituted legislative bodies. So that is incorrect because it forgets about the exception. And then D, yes, because taxpayers have standing to sue when questions involving constitutional rights are at issue. And that is incorrect. That overstates the law. They don't have broad taxpayer standing. They only have it in this limited area. So C is correct. Any questions about that? All right. So a couple of things about con law. Con law questions, generally speaking, and I'm going to switch over to essays. So con law questions, generally speaking, it has been tested twice it's been tested on the last 2 bar exams. So you will hear a lot of people say like, oh, I don't think it's going to be con law. I don't think it's going to be con law. Do not listen to predictions. I just I know most of you, and I've had a lot of you in my classes, and I'm sure you've heard me say this, but the bar examiners know what people are expecting and know what they're not expecting. Like, do I think so? On the last bar, it was Commerce Clause. Do I think you're going to get a Commerce Clause question? And I think there were a whole bunch of other issues too, but the big one was Commerce Clause. Like, is a Commerce Clause question likely? That probably is not. Like, you're probably not going to get something that is like, a narrower issue that's just been tested. Sure. But you could. And then the one before tested all sorts of issues. It tested like basically everything. So last February tested just a broad variety of con law. And con law is, generally speaking, not a favored subject by the bar examiners. They don't give con law questions like all that frequently. But that doesn't mean that you shouldn't expect it. That doesn't mean that it's not likely. Like, it is just as likely as any other subject. I think some subjects are a little bit more likely, ones that haven't been tested in a while. But it's still, don't give it short shrift at all. And I know that, that's my fear, is that a lot of people probably are giving con law short shrift. You need to know it for the MBE, so you might as well practice it for the essays as well. So that's what I have to say about con law and whether or not you should expect it. Maybe in the last week you're not focusing on it heavily, but like right now it should be getting just as much of your attention as any other subject. 2, with respect to con law. Con law for a while, or a lot of the questions that you will see and that you will practice for con law are specific calls where they're going to say, so-and-so brings a claim based on the violation of rights of his First Amendment rights. So that's what people are used to seeing, and that's probably what you'll practice mostly. But you should absolutely take a look at the past 2, and I think in particularly the February 2018 bar exam. You should absolutely take a look at that because it's a broad call. It's just like what claims based on the under the U.S. Constitution can the plaintiff bring, and so that is so much broader than what a lot of people practice. So I think it threw a lot of people for a loop, and so I just want you to kind of see the different types of questions that are frequently answered or asked, just so you're prepared kind of for pretty much anything. All right, any questions about that? Any questions about con law? Any questions about anything else that you guys have studied so far? Okay, so a couple of things. So I posted in the folders, it's an essay called Con Law 1. So I want you to, that's the one that we're going to work on tonight. I also left up the stuff that I've done before. I've just done those questions so many times, and I think that most people have seen them, whereas I don't think a lot of people have seen Con Law, the one that I posted that's called Con Law 1. But we left all those up, and the link is up, so you can watch me kind of go through these other 2 essays as well. I think it's a procedural due process and a First Amendment like advertising free speech issue, which is free speech is the First Amendment really in con law is the most frequently tested thing. So that's in con law, like that's what you've got to know that cold, just kind of how to go through that. But So tonight I want you guys to do question, the con law question 1, and I will give you like 30 minutes to go through it. You might need a little bit longer than that, but because I want you to go through and do like a full pre-write. This one is a broader call, and I want you to go through and do the practice at the end where check have you used every single fact in the fact pattern, and just take that time, take that full 30 minutes, and really write it all out. All right, so I'm actually gonna give you guys until like 7:45 to do that. All right. Oh, you can't see the comma? Okay, let me hang on 1 second. And yeah, the video for Compro it's up. Yeah, it's on the YouTube page. That one took forever to process for some reason, so it took like a day longer because I just like leave it up on running on my computer in the background. So yeah, okay. Oh, yeah, Luciana, did you see that? Just log out and log back in. You can see it. But let me, yeah, because I double checked. All right, so I'm going to pause. Sorry, I'm going to pause. So do that question, and then we will reconvene at 7:45. All right, you guys ready? Okay, good. All right, so tonight we're just going through this one. This is the only one that I had selected because we have the other ones. We have the other ones recorded, and it kind of goes through the other two that I would go through. And we haven't been able to get through two to begin with lately. So, all right. So first of all, we want to start with reading the call to question and making our list A. So I did something a little slightly differently here, but so the call to questions: what arguments could Pete or his parents reasonably make in support of their action, and how should the court rule on each? Discuss. So based on that, so I'm going to look above, especially because I just see like the numbers of the list popping out at me. So the 13th Amendment's involuntary servitude clause, the 14th Amendment's due process clause, and the 14th Amendment's equal protection clause. So really my list A could be what I have here, where it says for this essay. So I have 13th Amendment due process clause, procedural substantive, equal protection. And you might want to, like, for me, I didn't list this out in detail, but you might want to also list out, just some of the subheadings you would have under equal protection, so different classifications for due process, for procedural, life, liberty, property, for substantive, listing out fundamental rights or, some other basis. So you could have listed it out a little bit further as well, but I didn't here. I also just put my list A if it was like a general broad common law call. I just listed out all the different amendments. I also might put, standing, ripeness, mootness, mootness. Although it's rare that you're going to really need to discuss ripeness and mootness. I know that for those of you that are, going through with your bar prep companies, they will have that in a lot of calls. And it used to be something that needed to be talked about in every essay with common law, but it really doesn't anymore unless it's really at issue. But you do need to, it is still in fashion to talk about standing every time, even if it's not specifically called out. Generally though, like when you have something like this where it gets to, especially because it says Pete or his parents, so you're gonna want to look for claims for two people to make with 3 different claims each. So that's kind of a lot to get through. So I wouldn't probably spend time doing the stuff where I don't think it's at issue, ripeness, mootness. A lot of people will also include claims for the 11th Amendment. That, unless they specifically ask for it, I don't generally do that. So all of that is kind of out there. So I have my list A. And then I am going to go through and start reading the fact pattern. All right, so here it says, the legislature of state X recently completed a study. So they recently completed a study on the behavior of teenagers residing in the state that revealed the connection between an increase in the school dropout rate and an increase in the level of criminal activity. So I just note here, okay, so there's a connection. So they're going to do something based on this. But just because there's a connection doesn't mean that there is causation. So, correlation is not causation. The study indicated that the connection was most pronounced among boys aged 15 to 18. So then as soon as I see it say boys, I'm thinking, okay, is there some sort of a gender discrimination issue here? And then I'm like, all right, well, gender discrimination is subject to intermediate scrutiny. All right, so moving on to the next paragraph. Troubled by what it perceived as a breakdown in personal responsibility and social order among its teenagers, State X's legislature has enacted a statute creating the State Forestry Corps. So there's a statute. The Corps drafts boys, so they draft boys. And so it looks like it's just boys, ages 15 to 18. And so there's, looks like there's some, potential age discrimination there, who have dropped out of school. And then it only applies to boys, that have dropped out. It doesn't apply to boys who are in school. So there's kind of 3 different classifications there that you could look at. It also provides them with comprehensive education leading to a high school diploma. So there's, education, which you could consider. You could potentially say that that the state has a compelling interest in that. I don't think that is one of the things that has been spelled out by the Supreme Court as creating a compelling interest, but it's something you can make an argument for. It also provides, so to defray a portion of the costs, the Corps requires the boys to work on reforestation projects for a few hours a day. So now the state is benefiting based on this. So now the state is making money off of this. It also says, so it drafts boys, so it doesn't look like they have a choice. It's just if you were dropped out, you're a boy and you're within that age range, then you have to go to the Corps. And then when you go in, they're requiring you to do some work. So Pete, age 15, has dropped out of school and consequently has been drafted into the Corps. So he's been drafted in. So right there, I see, okay, there's no ripeness, there's no mootness, but I do want to establish that he has standing. So Pete and his parents have filed a declaratory relief action attacking the validity of the statute under 3 provisions of the U.S. Constitution: the 13th Amendment, the 14th Amendment's Due Process Clause, and the 14th Amendment's Equal Protection Clause. So, all right, so now I'm going to go in, I'm going to make my list B. So I'm going to draw out all of my different headings with each of the elements. So I have here standing, injury, causation, redressability, 13th Amendment. That little symbol is a no. So no slavery, indentured servitude, or it bars it. Due process. So whenever it says due process, you have to address both procedural and substantive. So I list out the elements. So is there a threatened interest? Really, you're not going to see a life interest. So it's going to be liberty or property. And it's really like in this one, I don't even see a property interest, but I do see a liberty interest. Process due, private interest affected, value of additional. So that's if there is a threatened interest that's been taken, what is the process that due? So have you not received that process? And then substantive due process. So looking, is there a fundamental right at issue? Is there a fundamental issue? And that is really where I think the parents' rights kind of come in. You could say it's a right to privacy, right to what one does, right to what one decides to do with their life, and then also with the parenting here. And then what is the standard if there is a fundamental right at issue, which I think there's probably going to be an argument here. So what is the standard, and does it survive? So if it's strict scrutiny. So here actually, and oftentimes in con law, you need to argue both. You really do need to argue both sides, kind of all over the place. So that's what, con law fact patterns like this one are often quite a bit shorter. They're often quite a bit shorter, and but that's because, it's going to require a bit more thinking. The rules are a bit more, they're big rules. You don't have like all these, for the most part, all these tiny little elements you have to show, like you might see in property or in contracts or something like that. It's going to be a little bit more conceptual. So you have fundamental right, you have the standard there, and then equal protection. So I'm looking for the classifications, and that's where I'm identifying. So, gender, and then I put my intermediate scrutiny, and then I know age and in school versus not in school. Those are both going to be subject to rational basis. So I'm going to list rational basis. So rational basis. All right, so I just am listing out all those elements here. And then I want to go through and match up all the facts. So I'm going to start at the beginning, and I'm going to go through my fact pattern. And I'm, like I've done in the last few, I'm going to highlight the facts as I use them and what I want to use them for. So, all right, so Pete, has he been an injury? Has there been an injury? Drafted into Corps. Causation, it says consequently. He dropped out of school and drafted into Corps. And then if court grants debt relief, then P does not. Oops. I'm gonna I like to just make these different colors just so for those people that want to look at it later. All right. And then, so does he have standing? Yes. Generally speaking, like your standing is going to be a pretty simple analysis unless they specifically call out standing as an issue, which they have done from time to time, saying that someone lacks standing, then standing, you're not really going to have a counter argument. It should be something that you can just show pretty quickly and move on. All right, so then next thing we want to deal with is slavery or indentured servitude. So the 13th Amendment, so one of the reasons I like doing this essay is because so many people, when they got this essay, were just floored. A lot of people couldn't remember the 13th Amendment, what it was, what the rule was, because it's just something that, like, I don't think it had ever really been explicitly tested before this instance. So this came up in July 2013. And a lot of people just you're in the stress of the test and you're like, oh my God, that's something that doesn't look familiar, even if outside that context, you would probably know what it was. That, a lot of people just didn't know, and it freaked a lot of people out. So this was one of the essays where people were like, oh my God, what is this? So, you will have an essay like this, you might have a call like this, or you can have an issue where you're like, I just don't know what to do with this, or a fact that you're just like, I cannot identify why it's here. So that was it on this one, and it's not that bad. It's not a huge thing. So 13th Amendment, it bars slavery or indentured servitude. So here, what they are, so the issue here is that, so to defray a portion of the cost, the Corps requires the boys work on for a few hours a day. So that looks like, requiring someone to work when they don't want to. And so so that's requiring someone to work. They've also been drafted. So, i.e. not voluntarily going into the Corps. Okay, so those two things, those two things show that it's a violation. Violation of 13th. Alright, so that issue's done. And the thing to note here is, like, yeah, it's specifically asking about this, and the fact that that requires the boys to work on reforestation projects for a few hours each day, like, that fact cannot really be used anywhere else. Like, you probably could, but it's going to be a little bit of a stretch, where, like, here, on this particular issue, like, this is really the only, this is what you need. So that's really what you needed there. So that's an instance too where it's not a big issue. You can see there's not a lot of facts there, so it's not a big issue. It's not really, critical to this essay. You do need to answer it, but it's not critical. And B, when you, if you go through this process at the end where you're highlighting all the facts and you haven't used that one, it's a hint to use it for that issue that they've specifically called out, or the 13th Amendment. All right, so then procedural. So is there a threatened interest, physical movement, fundamental rights, or choice? So I'm actually thinking here for both Pete and his parents. So Pete, is there a threatened interest? So liberty. So physical movement. So physical movement, he is sent. So it's limiting. He is sent to a camp located on public lands administered by state forest. So this looks like, he doesn't, can't really go anywhere else. Cannot leave either without permission or at all. Okay, so they likely cannot leave without permission or at all. So yeah, so they're restraining his physical movement. So that looks like that is a liberty interest. But also his parents, this looks like it's taking away their moving decision on how to raise their son. Checking the validity. Hang on one second. I saw in an answer somebody was talking about 15. Okay, so that was out of nowhere. Never mind. Sorry. We're just doing how to raise their son. So that is choice, I think. So there could be a liberty interest at stake for both parents and their son. And like that's when it says Pete or his parents, it doesn't say Pete's parents bring this on behalf of their son. It's really saying both. So this is kind of a unique question in that regard. So I'm going to say yes, and then here I'm going to say yes. Okay. I actually don't see any property interest, so I'm actually going to scratch this out. Unless you guys can make an argument for one, do you think that there's a property interest, or is it really just a liberty interest? I generally will talk about both of these, but I just don't think it's really necessary here. All right. So then, without that, then okay. Then I say that it's a liberty interest has been threatened. So then, what process is due? So private interest affected. So P and parents both have liberty interest threatened. Value is really high to protect a fundamental right, and you can just give them any sort of a hearing. And here, no hearing was given. They are drafted if age 15 to 18 and drop out of school. Like, there's no opt-out. I mean, that's generally what drafted means, is you don't have a choice. So then I definitely think that this is a violation. So procedural for both Pete and his parents. So procedural, yes, violation for P and parents. All right, any questions? So then that basically deals with procedural due process. So procedural due process, generally speaking, isn't a big issue, but here there are two different parties. So you do have to, you have Pete and his parents, so you're going to want to think about this and delineate those potential violations for each. So you'd want to just kind of walk through that. Let's see. Let me just do this. Any questions so far before we move into the substantive right and equal protection? No? Okay, good. All right, so then we want to look at, okay, so in substantive due process, we want to look at, is there a fundamental right involved? So I'm looking at, marriage, privacy, conception, or contraception, interstate travel, procreation, custody, parenting, or voting. So can you guys, I'm curious what you guys wrote for your fundamental rights. Can you guys tell me? If you're making like a privacy, like how did you frame the privacy argument or the custody parenting? Because this is where you really did have to be a little bit creative. Can you guys hear me? Okay. So were you able to come up with any sort of a fundamental right, like privacy argument or custody parenting? The parenting. What about privacy? And other people can answer, not just Sarah. All right, so I want to show you guys, because this one I think it was really hard. I think it was hard. Let me show you this, how some other people that did this did it. I think that the parenting one was kind of a bigger one. That's like the obvious one. But I think that you could make a privacy argument here. So these are just from the selected answers. So 13th Amendment, substantive due process, liberty is procedural. Actually, hang on one second. Here's the child. Because I just have seen on this essay, so I want to just show you guys like that. Oh, so it's also, sorry, not privacy. Sorry, I'm saying the wrong thing. So I'm sorry. So fundamental right, or if it affects a liberty interest. So like both of the selected answers here talked about liberty interests, which I actually really just think fundamental rights, but they both said because it did this essay just scare you entirely, Myra? Or everybody, I guess. Yeah. This one's a little bit tougher, and like this one, I think you really had to be a little bit more creative. And this one was really, like, generally speaking, common law essays freak people out because you do get stuff like this. And like the thing is most people in the room are going to be freaked out when they see a common law essay. It's people just generally don't like them. It's totally, yeah, because there was a lot of silence, so that's why I was kind of trying to check in with you guys. Um, so, um, so, so here, you kind of can be creative. So, like, I think what they were trying to do is they were saying, because I don't think that you can do this. Like, they were saying that it's that the liberty interest meant that it was a substantive due process issue. Um, so, because they're taking away life, liberty, property, but really, I think really it is here dealing with parenting, and that's why they put the parents in there. But I think you could just sort of make something up. Like, you could say this falls within privacy, because it's, what someone decides to do with their own time. These are decisions that are made within the home. You can kind of just go off, and I think a lot of people did make it up here. Hang on, let me look at this other one just to see. I just want to show you guys a variety here. This I can't share. Compelling interest. Hang on, because this is copyrighted by Bar Essays. Intent. Hang on. Like, reason, not arbitrary. So, like, and like the Bar Essays answer, like, they didn't even really address, they just said fundamental rights of privacy, and other ones address this too. Be forced to live in the camp, not live at home. Yeah, so I think that's where you can do it, Erica. I think you can make that because you're taking. I mean, that is a parenting decision, I think. So it's deciding, where your kids are going to live and like how you are going to parent them. So it's basically taking away all of those rights of the parent because their son no longer will be living in their home. So that's how. Does that make sense? Okay, good. But like this other answer also just says, they just say that it's a privacy right, and like they don't really go into the answer. So like this is somebody that's allegedly an expert writing this answer, and they just say that, and it's just this kind of like bald assertion. So I wanted to give you that because what you need to do on this essay, and essentially like this is a practice in when you don't know what to do, you just kind of make something up and go with it, and like because so many other people are freaking out, like the thing that you have to do is just maintain composure. And I know that probably sounds ridiculous and scary, but that just means on that essay, because when the graders are determining what's a passing essay, they're looking at a whole lot of essays. And there are going to be so many people that botch it that you just kind of have to sound coherent. And if you remained calm and just wrote stuff, then you did okay. So that's what you have to do, which is scary, and I get that. Yeah, no, I know, Mara. A lot of people did. So all right, but it doesn't mean that it won't come up. Like so many people were not expecting common law in July because it had just happened in February. And like that's like when I took the bar and everybody's like, you're not going to get pure remedies, you're not going to get pure remedies because they just tested it 3 times in a row. And essay number 1 was pure remedies. Like that's why I loathe predictions and I loathe trying to rely on things. I think it's okay to give it a little bit less emphasis towards the end, but I don't think it's smart to not do it. So, okay. So here, I think it's really the parenting. So Pete drafted into core, so sends boys to camps located on public lands. Okay, so camps located on public lands. So not living at home anymore. Removes parenting decisions from parents. Okay, so here I wrote, so I'm putting, okay, well, what's each side going to argue? So I'm like, all right, well, so the state's going to try to come up with an argument that this doesn't involve, marriage, privacy, contraception, any sort of a fundamental right. So no fundamental right because no right I don't know. I don't actually think you can make an argument here. Usually, generally speaking, I'll try to make an argument and I'll base it like I'll make it like a very, very narrow thing. So that's like you're framing something like, so here it's like, okay, well, right to parent. But here, no right to not go to school. Oh, I don't know, but you just make something up. I don't know that that's actually that great, but or it's definitely a losing argument. It's the only thing I can really think. So getting state for students have dropped out of school. Yeah, that's going to be a tough one, but for the state to make. But where the state's going to make an argument is that it adheres to. So then if there's likely going to be a fundamental right. Let's see. No, and then so my conclusion here is going to be, yes, violation of implicates a fundamental right. So it implicates that. Okay, and then it's what is the compelling interest? So here you really do need to argue both sides. And the argument that Pete is going to make, and his parents are going to make, is that there's no compelling interest in there's not a compelling there's not an established compelling interest in reducing crime. No compelling interest in the reducing and sending boys 15 to 18 because study shows connection to dropout and crime, but no causal link. State argument is probably going to say interest in ensuring an educated society because an educated society because they're dropping out of school. But I think that there has been something that's like up to the 8th grade or 10th grade, and I forget what case that is, but I do know that there is an actual grade that's indicated. So interest in ensuring an educated society, but also interest in reducing crime because recent study on behavior, there's reciting in the state revealed a connection between increase in school dropout rate and increase in criminal most pronounced among boys aged 15 to 18. Okay, so those are the two arguments really. All right, and then is it necessary? So is it necessary? So I think P and parents are going to say no, not necessary, because there are other ways to fix this. You could, so you can just think of something, more police. You could have, stricter laws to try to defray people from committing crimes. So there's at least a couple of ways here that you could do this, which makes it not necessary. So I'm going to say no. So not necessary. So I'm going to subject to strict scrutiny, fails strict scrutiny. So that's that. And then I want to go into the equal protection issue. So remember that equal protection deals with classifications. So here this is, and I think this is actually a pretty big issue here. They mentioned boys a number of times, especially, one thing here, recently completed a study on the behavior of teenagers residing in the state. So it did look at boys and girls, and now they're targeting just boys. So because it's most pronounced there, but it doesn't mean that it's not pronounced among females too. Must show. Okay, so here, what is the government interest? It is in. There is probably a government interest in reducing crime. Oh, sorry, gender. So, okay. Okay, gender. This is between boys and girls. And here you're going to want to think about like all of those things. Substantially return important government interest. So, between boys and girls, and like all of those cases that I'm sure that you studied that talk about, why it can be bad. Boys and girls. So it's most pronounced among boys ages 15 to 18. Study on of teenagers. It means they studied boys and girls, but only enacted laws for the boys. And like then I think, okay, well, why is this bad? So this is also because like the type of the work that they're doing. So requires work on reforestation projects. And I think that you can make an argument that this means that this is something that only boys are capable of doing. So this like reinforces gender stereotypes, which the Supreme Court has specifically denounced. Reinforces gender stereotypes. So I think that's a problem. And it's, so reducing crime. And I also just noticed a fact in here. It says troubled by what it perceived as a breakdown in personal responsibility and social order, which I want to use this above too in the compelling interest argument. Government interest. So what is this? So government wants to reduce interest. It wants to build up that personal responsibility and social order. So it wants to kind of set that back up because of what that can do in the future. That can have substantially negative effects in the future. So I'm gonna make it. So there's that interest. So that's probably what the state is. Oops. State, but I'm going to say parents. And here is actually really where I probably want to talk about discrimination against girls. Discrimination against girls. But I guess if the girls drop out, there's just no punishment. But they're not also then getting this education. Discrimination against girls. Long-standing policy against programs that reinforce gender stereotypes. So I think that there's, you can make an argument. I think the state's probably going to win here on that, but is it substantially related? So substantially related, this program is, puts the boys in camps, so could prevent additional crime, but might not. But there's nothing about that evidence that it will. We already, so probably like that, that's not right. And it's okay. Well, so they're going to put them in camp. So if their interest then is in preventing crime, you've probably got to show something that this is actually going to do that. But here, there's nothing that shows that. So I don't think it's going to even pass intermediate scrutiny because there's no evidence that it will have an effect. So I'm going to say that it will probably fail. based on lack of substantial relationship. And then I see, okay, age and being in school versus not being in school. And those are just both going to be subject to rational basis, and which are, you're going to use the same arguments, legitimate interest, rationally related. If that's the case, generally speaking, then it's going to pass under rational basis. So if that was the standard, then you would apply those. But you're going to make the argument that it really should be barred based on gender classification. Does that make sense to everybody? I know that's kind of a lot to go through, and you guys should definitely spend some time in the con law, in the selected answers. Yeah, this one, it is a lot. It's a lot. Okay, good. So let's just go through and double check with the facts that we've used them all. And as long as you have, like, you're in pretty good shape, I think especially on this particular essay. So legislature of state X, that, so you have state action. So we did completed a study on the behavior of teenagers residing in the state. Revealed a connection between an increase in the school dropout rate and an increase in the level of criminal activity. We use that. Study indicated that the connection was most pronounced among boys ages 15 to 18. Okay. Oh, and then we did use a troubled by what it perceived as a breakdown in personal responsibility and social order. We used that. State X's legislature has enacted a statute creating the State Forestry Corps. Corps drafts boys ages 15 to 18. Sorry, my highlights are getting messy here, but it happens. Who have dropped out of school. It sends them to camps located on public lands, administered by the State Forest Service. Oops. Yeah, whatever. It also provides them with a comprehensive education, leading to a high school diploma. I don't think I really used that, actually, the fact that it provides them with a comprehensive education. I think that I did use that just a little bit in the gender piece, because it's providing them with the education. But I'd want to kind of see where, so I think you could probably put that into parenting. With parenting from parents, I think I can add it in there. So forces education when parents may have decided they don't want their child. And this is where, like, knowing those cases comes into play, because I do know that there's a case where there's certain religious groups that don't want their children to get like the last couple of years of high school, and it's because of what is discussed and because of religious beliefs. So so that might come into play here. Okay, so that's that fact, and then to defray a portion, and this is where, like, the only place we use this fact to defray a portion of the cost was in that 13th Amendment one. So if you guys had, if you hadn't placed that fact, then that will tell you. So this tells you, like, if there is something you see that you're specifically asked about and you just have no idea, like, go through this process, because it will help you. Or, like, and if you have used every fact somewhere else, then look at what you've used the least, because that will probably tell you also. So Pete, age 15, so he falls within, dropped out of school, and consequently, so that's causation, has been drafted into the Corps. All right, and that's it. So we did use every fact. So, like, I find that when I go through this process where I'm going through the highlighting, I will note, like, 1 or 2 facts that I haven't used. And I'm someone that does these all the time. So it just goes to show, like, even, like, I looked at this before, and I'm like, all right, like, I know all the issues in here. And I've looked at it, I've read answers, but there still tends to be 1 or 2 facts that I haven't used, and then I'm thinking to myself, or just a more careful review, I'll go over and I'll see something like, oh, I can use that here too, and you'll note, like, another argument that you might be able to make in another section too, which can be helpful. So anyway, so that took us 35 minutes to go over. Obviously, it's going to take you less time than that, like, when you're just doing it on your own. And this is also just, sort of a harder question, I think. And you guys all have the bar essays code. You should definitely look at bar essays and determine, like compare what you pre-wrote and look at some of the 65s. This is the July 2013 essay. So definitely take some time to do that as well. To make a comparison to, what you even pre-wrote to what the 65s got on bar essays, because I'm sure you did just as well. So it's not as scary. Anyways, all right, you guys have a good night. This should go up hopefully tomorrow. It might take a little bit longer than that. But it should go up tomorrow. So, all right, have a good night, everybody. Good luck. Yeah, thanks. Oh, Crim Pro should be, Sarah. I'll double check. I went over to make sure that was ready today. All right, let me go double. It's up on. Did you look on the YouTube? Is that where you're looking? Huh. Yeah, because I published it. Let me just make sure. I've been having Wi-Fi issues, and just computer crashing issues. So I'll go back in and double check that. Thanks for letting me know. All right, have a good night.